Cool, I'm recording.
So again, thank you to everyone for joining in. Despite the circumstances, it's great for all of us to be able to connect and be able to have a discussion around, as we put it, the questions that a lot of people wonder, but not many ask. So first off, before we start, what I would like to do is give our guests the floor in terms of really just being able to introduce themselves to our listeners and to those who are joining in. We are joined by Gail Smith, Gordon Cudjoe. Did I pronounce that correctly, Gordon? I apologize if I didn't. Jordana Goldlist, Alison Craig, and Ryan Handlarski. Is that correct?
Good enough.
Good enough. Sorry, I apologize. So first off, just to get started, what I'll do is I'll give you guys the floor to introduce yourselves, who you are. Perhaps maybe we'll start with Gail.
Hi, can you guys hear me okay?
Yes.
Wonderful. So, Gail Smith, I am a practicing lawyer here in the city of Toronto, although my practice carries me west, probably as far as Milton, most of the time, east as far as Oshawa, south to the lake, and north, usually not much further than Newmarket. At any rate, my practice is predominantly criminal defense work, and I enjoy it thoroughly, being able to help others. Obviously, we fight for the underdog when we're fighting for those who are accused. So other than that, I dabble in real estate law and wills and estates in case anybody needs their will done. But other than that, criminal defense is the meat and potatoes of my practice.
Thank you. Thank you. Gordon, did you want to go next?
Not really, but I will. I am working in legal aid. I manage the big case management department. I was on the ground with many of you for 15, 16 years. And lest I throw the criminal code at the bench and get myself in contempt, I decided to move on to other things. So now I'm at legal aid, managing the big case management. And I also spent some time teaching at York University at Osgood Hall, teaching race and evidence, where I can let loose and tell them what it is.
You've got lots of experience all around. Thank you. Next, Jordana.
Yes, criminal defense lawyer based out of Toronto with a large practice on the West End, so Hamilton, Brampton, Brantford, all the way out to St. Catharines. I do not go east of DVP, preferably when I can avoid it. I have the occasional case that brings me as far as Barrie or Orillia, but they're few and far between. And my practice now is focused on really high-risk cases. So most of my cases are firearms, drug trafficking, and homicides. I don't really dabble in much other than those. And I've been working with Keep Six now for about the last year, when we were allowed to venture out of our homes, going to schools as well as community centers, and trying to educate people on the trap of the criminal justice system, which is something that I speak about as often as I can.
Thank you. Thank you. Jordana has been a firehouse when it comes to Keep Six, and we appreciate you. Thank you. Alison.
Yes. I'm a lawyer in Toronto. Most of my practice is filling out paperwork that Cudjoe requires me to fill out. But when I'm not busy doing that, I do mostly criminal defense and a lot of correctional law as well. I practice all over the place. I'm in London a lot, Barrie a lot, Cornwall, Ottawa, all over the place. And I do both criminal defense and a lot of correctional law as well. So parole hearings, that sort of stuff, which is keeping me pretty busy these days.
I can imagine, especially with what's going on right now.
Exactly.
And Ryan.
Yes, also criminal defense lawyer based out of Toronto, but my practice takes me everywhere. I've had cases in Thunder Bay and Sudbury and all throughout the GTA. Also, my practice tends to lean heavily towards serious offenses, like Jordana was saying, drug trafficking, firearms, homicides, and armed robberies. So that's the bulk of my practice right now. And I also have a blog, and I'm interested in engaging in issues like the ones being engaged in now. The one Jordana talked about, I've often spoken to her how much I enjoy her take that the criminal justice system is designed to trap people in. So I'm interested in that issue, and I usually come at it from a different perspective than other people. So I enjoy having those discussions like we're having now.
Thank you. And last but not least, Richard, if you wanted to introduce yourself to those who've recently joined. Oh, you just got to unmute yourself.
Thank you. So I'm Richard Miller. I'm the founder of Keep Six organization. I founded Keep Six after coming across a lot of unjust corruption and overrepresentation within the justice system. I had the opportunity to navigate through it and had support, and I was privileged enough to say that even one of our panelists here was actually one of my defense team and supported me to the birth of Keep Six, actually. So Keep Six offers mentorship programs. We also offer a program in the trade sector. We also have a program going on called Guns for Tuition, where individuals are able to turn in firearms, and in turn, we support them in getting them into the trade to get out of that criminal lifestyle and get them into being a positive role model in the society and contribute back. That's one of the programs that we're offering to attract or deal with one of the crises we have in the city, the guns and homicide. And that's something that Jordana is a part of with Keep Six.
Thank you. Thank you. So I want to thank you all for introducing yourselves. And without further ado, I guess we'll just get started right into this discussion. So Richard had wanted for us to have a discussion based on some of the recent news that came out recently in regards to Marco Muzo, who is an individual or a case that many of us may be aware of. He was an individual who was sentenced to 10 years based on 4 counts of impaired driving causing death and 2 counts of impaired driving causing bodily harm, which was the death of a family of 4, so a grandfather and his 3 grandchildren, all under the age of 9. With this particular case, this is an individual who received a 10-year sentence. He served 4 years, at which point he was recently granted day parole. And one of the interesting factors that a lot of people have also mentioned is that his family owns a billion dollar business. So there's also, he comes from a family of wealth as well. A lot of the information that's come out even from inmates who were inside with him was that it could have been said that he received the white glove treatment, just in terms of being granted parole so early, even just his from him being in Joyceville, going to Beaver Creek, going into minimum, having PFVs granted very early. There was a lot of conversation just around this possibly being the white glove treatment. So the question at hand really is, what are your opinions looking at this case if you are familiar with it? What do we typically see, or what have you normally seen with cases that you've dealt with personally, and how may that compare what we're seeing with this particular case? I guess we'll work backwards this time. So Ryan, if you want to go first.
So in terms of my thoughts, in terms of whether he received the white glove treatment, I'm not sure I can comment whether he received the white glove treatment in terms of his assessment and how he was treated at the institution, and whether someone similarly situated would have been at Beaver Creek or a medium security institution. But in terms of the parole, my thought was that it wasn't based on white glove treatment or his wealth or his race. I think parole is something that's often very misunderstood by the general public. Parole, if you think about it, is a very intuitive process. You've received a 10-year sentence, let's say. You're going to get a statutory release at 2/3 of your sentence. Why? So anybody's going to be released at 2/3. Why? Because the person who's been in jail for however long needs a window to be reintegrated from going from a custodial setting to being completely free of any conditions at all. So that process to me is completely intuitive. So let's say at 2/3, he would have been paroled, say, at 7.5 years at the latest. Think about it, he's paroled, he was sentenced after 6 months. So with enhanced custody, he had 9 months in at the time of his sentence. Plus you get additional credit for time spent on lockdown. So let's say he had another month or two as a result of being on lockdown when he was in custody. So he had 10 or 11 months in, plus he served 4 years. So he's getting parole at about half. And what the parole wasn't full parole, it was to be paroled to a halfway house. So he's going first to a halfway house where they're under curfews or they're under all sorts of conditions that they have to abide by. And if they don't abide by them, they go back into custody. I'm not sure I see anything nefarious about it, or it has to do with his wealth. To me, it has to do with the fact that, okay, he served 5 years of a 10-year sentence, and they're managing the process from parole that he's on now, the kind of parole he's on now, to full parole when he can be, for example, back at his own home, while still serving his sentence on parole. So there may be other reasons that have to do with his wealth and the white glove treatment he may have received while serving his sentence. I don't know. But I don't see that being related to getting paroled at 5 years of a 10-year sentence.
Thank you. Thank you. Alison, did you want to go next in terms of what your thoughts are?
Sure. I agree with everything that Ryan said. And one of my biggest pet peeves doing a lot of parole work is that people don't understand the parole system. And they just think everybody's getting out of jail without having served their sentence, and it's a complete outrage. From everything I know about this case, it sounds like it was the right result. Particularly in cases where it seems that, substance abuse, for example, may have played a big role, that sort of thing. Once somebody has completed their correctional plan, so when you go into a federal custody, you get a whole plan laid out of the, for the most part, useless programs, but that's another story that they want you to do. Once you've completed those, there's nothing left for you to accomplish in custody. And for the most part, and research shows, gradual release is the right way to successfully reintegrate somebody. So at least from everything I know about his case, it was the right result. The problem I do see with it is that the parole system is not applied uniformly. I think that, at least in my experience, when there's particularly high profile cases where deaths have resulted, if somebody is a visible minority, if somebody is not economically wealthy, I bet you they would not have been given parole. The parole board, at least in my experience, seems to be much more lenient with people who are from well-to-do backgrounds with, no criminal records and that sort of thing. It also, I noticed, at least on the day of the parole hearing, it seemed to be an awfully short hearing. I think I was hearing news about what had happened like 45 minutes after it started. And I have sat in on many a parole hearing where, you know, my Black or poor or drug addicted client was grilled for hours, particularly in such a high profile case when, you know, death resulted. So I think it was the right result, but I'm very skeptical it would have been the result that a lot of other offenders would have achieved.
Yeah. No, and definitely, especially when it comes to minorities, that is definitely a topic of discussion for sure.
Yeah.
Jordana, any thoughts?
I mean, I don't think we ever heard that Marco Muzzo suffered from some sort of a substance abuse issue that we can factor that in. He was a rich dude that took his private jet to Vegas, came home plastered, and decided to drive drunk instead of getting an Uber that he could so easily afford. So I don't know that I want to cut him the same slack that I would someone who really has struggled with addiction issues. I think that when we talk about the interplay between race, ethnicity, and wealth as it relates to this particular case, we have to look at the position he would have been in because of his race and wealth when entering the justice system. He would have already been in a position of advantage when he first got to jail and his release plan was created for him. I seriously doubt that the institution would have forced him to take the same classes in, let's say, learning life skills or making better choices that others would have had to endure who weren't from the same socioeconomic background. And so I can see when we talk about the white glove treatment, I don't know what his treatment was in jail, but he most certainly, his starting position was already advantaged by virtue of the fact of his race, ethnicity, and certainly his wealth would have put him in a position of privilege from the get-go. So completing those programs, which would have been likely a fraction of what we see from some of our other offenders, would have been easy, which made it easier for him, of course, to see parole at the halfway mark of his sentence. So I think that certainly did play a factor, not necessarily directly at his parole hearing, right? I don't think he was granted parole because he was rich and white, but he was able to position himself to be paroled because when he first entered the system in the first place, he was sort of able to take advantage of his position in life. That's sort of my take on it.
Thank you. And Gordon.
Okay, I have to get used to this unmute button over here, but sometimes you have to mute me because I may not stop. For me, this topic is sort of just a smaller microism of the larger issue. We're sitting here watching him coming out after a 10-year sentence. 3 people died in a car accident for which he decided to get behind the steering wheel and drive, and these people got killed. I'm looking at the 3 deaths, and I'm looking at all the sentences people have got for other things like possession of a firearm, anything to do with the drugs, guns, and all those other things, and the mandatory sentences that have been attached to these things. And I asked myself, is the issue that he got 10 years and he's out in 5? Or what is Canada penalizing? And why are jails so full of young Black men? When we have this great fear of the crack cocaine dealer, and he's going to spend 15 of his 30 years on this earth in jail. You ask yourself, why are we penalizing that a lot harder than other ones? Well, guess what? Everybody can drink and drive, including the judge, the crown, everybody, and kill somebody, and they can possibly sympathize with that. Well, if you can't sympathize with the way somebody's grown up and the choices they made because they think they have no hope, then you're going to focus on those ones, and that's what's filling our jails. And that's what to me, the real concern is how is the legislature coming up with punishment for people, and the courts as well, such that we have such a skewed justice system. I'll give you an example. Very early in my career, I was running a bill hearing as duty counsel. And the Crown started to focus on how many bedrooms mom had to take her son home and how many children she had. And her last question was, Well, if you have only 2 rooms, where's he going to sleep? Well, which mother on this earth won't find a place for the kids to sleep in whatever size house they have? I thought it was completely irrelevant, but the court was nodding and listening to him. It's a systemic bias that people are only willing to see what their world looks like and not understand other people's worlds. So this question on his parole, I agree with Ryan and Alison on that one. He got what he deserved based on the system that we put in place. The problem is the system that we put in place is not giving other people what they deserve.
Thank you.
Thank you very much. I just want to interrupt you quickly there. I just wanted to say something towards that. I think the focus is basically not even about what Mr. Mizuko's sentence is, but just about the system itself and overall. And one of the points, last week, I was just on a show on the weekend with another celebrity lawyer. And my argument to him was the fact that the judge had the authority to set a precedent regarding this case. And my point was that he could have sentenced this individual to 20 years with not able to apply for parole for 10 years. But I didn't feel that the judge or the Crown took this into consideration. They more or less had their Crown meeting and came to some resolution and then to this guilty plea, and then the charges dropped down all the way to the lowest level of just a DUI. But before I go further, I know, Rachel, you have to go, and I just seen that Ray came on, and I'd just like to introduce Ray. Ray is a professor at Humber, and she also volunteers with Keep Six, and I'd just like to introduce her and maybe have her join in here. She's a criminology professor. Ray, are you there?
Sorry, I am here. Good evening, folks. I apologize for joining the conversation a little late. I was struggling with my technology. So if I missed I did miss some of the earlier comments. So I do apologize for that and wanted to say a very warm welcome to our panelists and thank you so much for joining the discussion. I think for me, one of the main concerns, and I agree, with what Jordana said and what Gordon said, and I don't know if I missed Alison. I'm not sure if Gail has spoken as of yet, but I do agree that this is a larger systemic and institutionalized piece. And one of the things for me that's really important is that the discourse around, the fact that the system is broken, right? That's always kind of the common mainstream narrative that we keep hearing. And the reality is, folks, the system is actually not broken. It is absolutely fundamentally not broken because it has been designed to do exactly what it is doing, which is keep marginalized folks trapped in the system. It is designed to keep people who are poor and vulnerable in the system. And historically, when we look at the construction of the Canadian nation state as a settler society, quite frankly, right? And we look at the designing of our criminal justice system, that was not done with the premise of thinking about people who were racialized, right? It really wasn't. So it was really a system that was designed by the white founding forefathers to keep their power intact. It's structurally embedded in our codes, in the way in which policing takes place, the way in which the courts operate, and finally the way in which carceral procedures take place. So this common narrative that we keep saying politically, right, and socially that, there's something wrong with the system. No, if we really think about it, the system is designed to keep people who are the most vulnerable and the most disenfranchised exactly where they are today. That is how the prison industrial complex works. And until I believe that we're able to have really concrete discussions about, whiteness and white supremacy, and those are hard topics for people to talk about, really, really difficult topics, particularly in Canada where we have this fallacy of multiculturalism and, equal opportunities for a number of folks. People don't want to have conversations about race. Right? We don't want to do that. We pick out the quote unquote bad apples and we assign narratives to those folks. But the reality is the system has been designed like this from jump, right? To keep people who are the least desirable in our country, right? After this land was stolen from Indigenous folks, to keep them in their place. Right. And so I just wanted to add that piece to the conversation because I really think if we're going to have a conversation about race, ethnicity, and exclusion, then we cannot disavow the very way in which the system was designed from the first place.
Thank you. So we can
I
carry.
believe Gail, I think Gail was next. Gail was the last one to speak. Thank you, Ray.
Thanks very much. I agree with just about everything that's been said thus far. I think that this is a problem, this being the differential treatment between racialized persons and white people. The distinction needs to be acknowledged from the very beginning of the process. As Gordon was indicating, he had a case whereby there were challenges to the mother, where's she going to house her kid? From the bail process to ultimately to parole, there are elements of the system that make it difficult for anybody who is disenfranchised, anybody who is not wealthy, anybody who hasn't got the means by which to access persons who are going to be able to navigate the system effectively. What we have is a society that is not only biased, but prejudiced. And quite often, the persons that are demonstrating those attributes are doing so unconsciously. And this is something that we need to address. We need to get persons to the point where they can acknowledge the racism and the biases with which they work, not only acknowledge them, but then formulate ways to work around them. And it's going to be an uncomfortable discussion, but it's one that needs to be had.
I'll just jump in before we move on to the next topic, because Gordon, the example he told about the cross-examination of where the person, the mother was bailing out, was going to sleep. I had that exact line of cross-examination at a bail hearing earlier this week. The mother had 4 children living with her, not including the accused, my client. And she said, you know, we have a futon in the living room and I have no problem. You know, I want my child with me under my roof. He can sleep there every night. I have no problem with that. And the cross-examination about that went on and on and on forever. And it was either early last week or late the week before, just kind of as a stark contrast. I had a white client from a pretty well-to-do family who had been in custody for a grand total of 2 days waiting for his bail hearing. And in that 2 days, the mother, who was his proposed surety, went and found a brand new house to rent that was bigger than where she was living at the time. She had the cash to just go out that night, find a big 4-bedroom house out in the suburbs that was just lovely, rented it, signed the lease in time for the bail hearing, and had already purchased some furniture that was on its way to accommodate her son that she was bailing out. So it was a pretty stark contrast within less than 2 weeks.
Okay.
Go ahead, Richard.
No, go ahead, Ray.
I was just going to jump in just really quickly. Rachel has asked me if I would be so kind to help with moderating, that she had to leave expeditiously. So if maybe between Richard and I, we can work on that. So I'll turn it over to you, Richard, and then I wanted to also hear from Ryan in regards to the same topic that we're talking about.
Yes, thank you. So one of the things that I wanted to point out was, and Alison, I mean, between you and Jordana and Ryan, how do you feel with your clients that you have represented and the situations that they've come across, navigating through the system under the circumstances and not having the financial stability like these other individuals, like, for instance, like Mr. Marco?
So I can, if you guys don't mind going first, there's no question that wealth is going to be a factor in something like, for example, bail. I don't think that's avoidable. And I don't necessarily attribute it to race. I represented a black client recently on a bail, who the family, they own their home, and they both parents have good jobs, and because both parents were working, they installed a detailed and fulsome home security system with cameras pointed at the door of the room where the accused was going to sleep, and all doors at the back and front door and side door of the house. And the plan of release was that the accused was going to be at home when the parents were at work, when the COVID-19 shutdown is over. That home security system is expensive, and he was going to be subject to electronic monitoring at their expense. So the family had the means, they used it to improve the plan of release, and that's just a factor. It's going to be a factor in a bail plan of release. And I'm not sure that anything can be done about it. I guess what I'm saying is, I'm not sure that it's improper, that it is a factor. They had this home security system that was very fulsome, and it was going to be connected to their phones, and they knew where the
dollars to a multi-billionaire, just to use an extreme example. So wealth is a factor. I don't think it should be, because what's important, as far as I'm concerned, for at the bail stage is, the amount of money to the person and what it means to the person, rather than the actual number that's written down on the paper. So that drives me nuts. It's definitely a factor, and it shouldn't be. The other problems you run into often is, immigrant families, for example, and racialized families. Often every family member is, working 2 jobs, 3 jobs just to make the ends meet, and they aren't able to come to court and say, we have a 24-hour plan of supervision. One of the sureties can be with the person at all times, because they don't have the financial resources to do that. And that's another problem. And we're getting to the point now, it seems to me, particularly of late, where courts are wanting to see bail plans that include 24-hour supervision, somebody with the surety or somebody with the accused at all times. Despite what the Supreme Court has said about the fact that, the least onerous form of bail is what the default should be, that's far from the case. And if you have a family that everybody works 2 jobs and nobody can be with the accused all the time, that also creates a problem. And so wealth and financial resources are definitely an issue, and they really shouldn't be. That needs to somehow be reassessed. And I argue till I'm blue in the face every day, but it hasn't changed yet.
And it's a catch-22, right? Because you have someone perhaps who's receiving OW and ODSP who is available to supervise 24 hours a day, but they don't have the resources to be able to pledge, $10 or $15 or $20,000 to secure someone's release. And so that becomes a point of contention. And then on the flip side, of course, you have hardworking individuals who need to work in order to have that money to pledge. And I agree, in the context of bail, it's becoming increasingly difficult to get people out who aren't of the means where, there's a stay-at-home mom, for example, to watch. And the situations of those individuals entering the criminal justice system in the first place are few and far between, because those aren't the communities, of course, that the police are out walking around policing. So, we are in a situation where the same issues that arose when carding was something that was appropriate are still at play in all respects. And so you have people from marginalized communities who are arrested more often and have a harder time getting bail. And one of the things I'm most frustrated by these days is the fact that the courts right now are only open to people who are guilty pleas. And they are extracting guilty pleas at an unprecedented number due to COVID-19, setting the stage, of course, for individuals to stay stuck within this revolving door of the criminal justice system. So, from a defense perspective, it is very difficult to try to convince my client to stay in jail for an indefinite amount of time, because I can't tell them when their trial might be, when the Crown throws a guilty plea on the table right now that says they can get out, but they're not eligible for bail. So we have a system right now that is really at a breaking point.
Hmm.
Gordon, you have anything to add to that?
Oh, I listened to Ryan, and I see the purist in your thoughts, and it's unfortunate that you got photobombed, because this discussion needs to, sorry, this Zoom bomb, because this discussion really needs to be had. There was a lovely speech by Justice Laforme at the opening of Ryerson Law School, which I'm not that articulate, so I'll try and put it in 2 or 3 words, but he was comparing equality to equity. If the goal is that everybody in Canada is entitled to reasonable bail, how is it that we've come to a system where now that is now dependent on how much money you make? Then it means it's not everyone anymore. When you make the equal rule for everybody, but you don't think about the inequities of everybody, what you're going to end up happening with this is this an unfair rule. Because if everybody is entitled to reasonable bail, why are we having discussion about rich and poor?
Mhm.
That's, and I'll stop on that, because I hopefully will get through some many more topics on this. So that's my comments for now.
I was actually hoping, Gordon, I wanted you to expand a little bit more on that. So maybe the other panelists, Alison and Gail, maybe you folks can add your perspective on, because I think what we're also talking about here is very much a tiered and a class, of course, a justice system, right? So given that each of you have, varied experiences working around sentencing disparities, I'm wondering if maybe you can speak to that, and I'll open that up to Alison, to Gail, to Jordana, to all of you, in terms of the point that the point that Gordon just finished making.
Well, I'll start, because I can underscore what Alison was saying. And the fact that we are not looking at how much something means to the individual. I mean, I remember being back in articling a number of years ago and watching my principal do a bail. And I remember even back then, he made reference to the fact that this wasn't Bill Gates who was coming to stand as surety. This was this impoverished person who was coming to stand as surety. And the impact of potentially losing that which they were pledging would be so much more severe than asking Bill Gates, let's say, to pledge $2 million. And I don't think the jurists take into account who it is that's standing before them. I don't think they really take into account who it is that stands before them, especially when there's been a pattern and a growing pattern of looking for further assurances, be they a monitoring bracelet, be they, video security systems, whatever. It's like they get wrapped up in, it takes flight. The whole idea of how else can we make this a stringent bail, when in fact it's moving from how little the person who cannot afford these various things will be able to afford bail to the point where really very few people might be able to afford bail, because in fact those people who can afford are often, as Jordana said, not even monitored by the police, or often not even picked up for the crimes that they are committing. So I think that we need to take a step back, take a look again at the words of the Supreme Court, recognize that everyone means everyone, because truthfully, bail is built on trust. And it doesn't matter, short of a monitoring bracelet, it doesn't really matter. If you've got sureties who are saying, I'm going to watch this person, a surety has to sleep at some point, right? So it is built on a certain element of trust. And if we work in a system where they start from a presumption of innocence, then the presumption of bail should be in place until such time as somebody proves differently, that they shouldn't be awarded bail. So I think, we need to return to basics when it comes to bail and who it should serve, which is everyone.
Just everyone. Thank you. Very well said. Alison, did you want to add any comments there?
Well, I would just add to what everyone said and what I said earlier about the financial issue. Another problem that I run into fairly often is that the revolving door of the criminal justice system, and frankly, not even the criminal justice system, but contact with the police, becomes a family and a community issue. Because like Jordana said, you know, the police certain communities and not others. And so when, you know, someone from that community then gets arrested, and that community is where their whole family and, you know, support network is, it sometimes can become difficult to find 3, 4, 5 sureties, like the courts often want to see in particularly serious cases, who can come forward and offer themselves as surety and haven't had, you know, prior police contact. Not that that should in any way stop them from being a perfectly appropriate surety, but in the eyes of many crowns and many courts, it does. For example, I don't know, maybe 3 or 4 months ago now, had a client from a particular community who the police very much over police, and he was arrested and charged with some serious charges. And I had sent all the proposed surety information to the Crown Attorney in advance of it. It was a special bail, so I had sent it all in ahead of time. And the Crown had the officer in charge go and pick up every occurrence report from every contact each potential surety had ever had with the police. And of course, they all had had many. They live in this community. They are harassed by the police constantly. And so cross-examinations, until I was successful in eventually stopping them, about prior police occurrence reports. Well, sir, you were stopped by the police, 5 years ago while you were walking down the street and refused to give them your name, correct, sir? So, you know, how is this court supposed to trust that you're going to cooperate with the police now? That sort of thing. And it went on and on and on. And I'm certainly running into that pretty often these days, finding sureties that, you know, haven't had police contact, and that, you know, prior police contact, as innocent as it was, you know, being brought up at bail hearings and sometimes being used to find that sureties are unsuitable when they are absolutely not.
Absolutely. Thank you so much. And Ryan and Jordana, did you want to add any comments before we move on?
No, I mean, I think it's a circular argument, right? The police are focusing their attention on certain communities, and those are the communities that have the most difficult time getting bail. And it's, you know, those are the communities that are most often squeezed out for guilty pleas early on, especially as, you know, teenagers, where they're told, oh, it's okay, it's just on your youth record, except then you're caught again doing something, you know, small and silly that the police probably wouldn't even bother looking for in other more affluent communities. And then you're back before the court again. You can't get bail because you have a whole series of failed to complies on your record. So now you quote unquote can't be trusted. It's really that is the basis for the trap. And it starts with kids when they're young, so that by the time they get, you know, into their late 20s and early 30s and want to leave the life completely, they now have a criminal record that prevents them from getting the proper employment.
Did you get in?
See as being, you know, trusted individuals. So I sort of all part of the trap.
Absolutely. Absolutely. And Ryan?
Yeah, I agree with everything Jordana said. I've also noticed it came up at a bail hearing, a client who recently had that type of experience, a racialized client in an area that was over-policed, and had his charges eventually stayed after a preliminary inquiry because of the obvious charter violations, the obvious arbitrary arrest and improper search, unreasonable search. And at his bail hearing, the Crown raised that he had previously had these charges that were stayed. And the Justice of the Peace, despite my objection, admitted it into evidence. So just a further example of the trap that Jordana is talking about. You live in an area that's over-policed. You are improperly arrested and searched. Drugs are found. You hire a lawyer. You do everything right. Your charges stayed as a result of the Crown seeing that there's no prospect of conviction, and you're arrested again. And the justice who's determining bail hears about the previous charges, which did not result in a conviction. So yeah, I completely agree that there's a cycle that becomes very, very difficult to break. Even if you do everything right, even if you win, it can still be used against you.
Absolutely. Thank you. Richard, go ahead.
I just want to bring someone here who I noticed has been on here. It's Valerie Steele, who's a very community member for a long, long time who I've been working with. And Valerie, thank you for coming. I would just like to hear your point of view. I know you've been on, I just noticed you here, just to give your input. I'd appreciate it.
I am intrigued. Good evening, everyone, especially Gail Smith. You look wonderful.
Good evening, Valerie.
I hope everyone is safe and sound. You know, it's so interesting listening to all of you this evening, because when someone talked about justice is supposed to be for everyone, it means everyone. That is the way I feel about that. And the over-policing of certain communities have definitely caused many of our people to be in jail and or have records that they shouldn't have. So for me, from where I sit, I've always felt that the judges really need to be more community-minded. I have been to court and I have sat down and I have listened to people giving evidence, and I know what's true, what sounds true, and I know I'm not a lawyer, but some things are just outright lies. And then when the judge is making his summation, he's speaking about how the officer was so truthful and he was so honest and he has to believe him. And you sit there and you figure, no wonder these kids keep coming back to court, because they know that this is a jig and it is a circular issue. And I don't know how we're going to change that. I don't know how we're going to change that. I am the vice president of the Black Action Defense Committee. And in the days of Dudley laws, you know, when we demonstrated on the streets, etc., 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 those days are not necessarily gone. We might have to come back to doing some of that. But it just seemed to me like everything is getting worse as an old soldier. And I leave it at that.
Okay, thank you very much. Tafik, I think Ray's muted again, accidentally. I just wanted to have just a personal opinion, especially from the legal aspect of how do you guys feel that it could be changes, especially when it comes within the court from the judge. I feel the judge has a lot of power to make changes and to look at circumstances in a totally different open view, which I feel that doesn't take place within the system itself. I myself experienced certain things within the system, and that's what brought us here today from my own experiences. And fortunately, for me, I had support and I was able to have the education and knowledge to address the issues that I came across. But from your point of view, being in the courtroom every day, 5 days a week, what's your take on it? You know, even Jordana, starting out with you.
On what we need to do to make change?
Yes.
Well, I think that parts of the system need a complete overhaul. I am a big proponent to eradicate probation entirely. I think probation terms do nothing but keep someone in the system and give the police and the courts an excuse to create a criminal record for someone that does not have any benefit to that person or to society. It is literally just a system of observation in the community. There's no real counseling that's attached to probation. I've never had a client tell me that they felt that probation was beneficial to them in some way. And so the entire system of probation has created this structure where, you know, you have let's say, more youthful offenders, because I think that's where it starts, where, you know, kids are teenagers. And so you have a youthful offender who's given probation for a minor infraction, and then they fail to show up at their probation officer's appointment. They're charged, they're arrested, they're again brought for bail, which gives the justice of the peace the opportunity to detain them. If they're detained and it's just a probation, they end up with a lawyer who most likely convinces them to plead guilty. At least that's what I see for most of my clients. So now they have another entry on their criminal record, which will later be used to justify another detainment. Like, this is really what is driving the cycle, is these minor offenses. I have guys now that are coming to me, you know, in their early to mid 20s with 4-page criminal records that have never seen a trial. It's an absolute travesty what some defense lawyers are doing to their clients, allowing them to accumulate these criminal records because it's easier, because they can do, you know, 5 or 6 guilty pleas in a day and make more money than some of us who are prepared to take things to trial for a couple of days. Right? The reality is there's this horrific imbalance, and I think I see Gordon smiling a little bit because he knows that the legal aid system right now is designed in such a way that it is more profitable for some lawyers, depending on their practice, to actually run what we call these dump truck practices, where they're pleading out multiple people in one day, sometimes in one courtroom. You know, I've walked into a Jordana matter and I see another lawyer tell me that they have 5 or 6 pleas on their docket for the day. That's 5 or 6 people that they're adding entries to someone's criminal record, which is just helping them stay within the system. And so I think that we as participants in the criminal justice system need to figure out a way to stop this practice. We need to start, you know, doing a better job of making sure that clients get bails and clients get the trials they deserve. I had a conversation with someone today who was so excited that, you know, now with COVID-19, there's been an extension of the courts to allow for out of custody guilty pleas, but we still can't go in and do trials. But the constitutional right of every person is to the trial, not to plead guilty and give up your right to a trial. So I think that, you know, those of us on the defense side, and I don't say this to any of my colleagues that are on this panel because I know them well as, you know, those of us that are fighting, but we need to find a better system that helps get people out of the system early on.
Thanks. And Gord, what's your take since you're in the legal aid sector?
Well, one, a disclaimer, everything I say has nothing to do with what legal aid says. Because I'll be joining you in the private sector very soon if I don't put that out there. Jordana, just to put your comment in perspective, a full day of trial, fighting for your client will give you, if you're at tier 3, about $1,200 to $1,300. 5 pleas in one day in a courtroom right next to will give you $4,000. You can see the impetus for people to plead their clients. What do I think about it? I think about the whole system has gotten us to a point where we are just moving people through a factory. And Richard, you said from the beginning, you think the judge has a lot of power. Maybe they do for the one individual before them, but they don't have a lot of power in adjusting the system to assist anybody because they deal with the cards that they're dealt, whatever is put before them. They can't go out and direct the police to go to other areas to stop looking for things to bother people with. We saw this, and I can bet you almost every single defense counsel on here would have seen this trend. Your client starts at 14 years old being arrested for possession of marijuana. Then it's a fail to comply. Then it's a fail to appear. And now they're known to the police, and the police are turning them over and over again. And in 6 years, your client has shot somebody on Young Street in Eaton Center. The system drove them into the ground. And so, if we wait for the judge to deal with it, it's way too late. Because the 14, 15-year-old, when he wants to work at 16, the first question on the Walmart form that's going to give them minimum wage, which is now increasing because of COVID. So it's like $18 an hour. They can't get those jobs because they have the fail to comply, the fail to appear, the possession of marijuana. And the first question is what? Do you have a criminal conviction?
Yeah.
And the first day you go to court, there's some lawyer waiting to say, I can get you out of this courtroom really quickly. Just take the deal that the Crown is giving you. So by the time you actually see Jordana walking down the street, you've already pled guilty and you're going home. So that's my comment on that.
Thank you. And Alison? Your mic.
You're still muted.
There we go. It wasn't letting me. Okay. I totally agree with everything. I'm totally with Jordana. Probation drives me more up the wall than anything. And I think there need to be, in addition to getting rid of probation entirely, I think there needs to be a lot more sentencing options, if you get to that stage, that do not result in criminal records and provide community supports to the people that have found themselves in front of the court. If that kind of stuff starts, widely broadening diversion programs, for example, if that starts early on and you get people community supports and, you know, pointed in a bit of a different path early on before they accumulate a criminal record, I think that can make a huge difference. I think the bail law needs to change drastically. I mean, supposedly bail is the norm, or should be. It absolutely is not. I think the vast majority of people should be on bail pending their trials. So that will result, hopefully, in stopping the revolving doors of guilty pleas and then new arrests and then having to plead guilty because you can't get bail, just like Jordana was talking about. That has to change. But I think also the changes need to start before people even find themselves before the criminal courts. The whole community structure, particularly in the over-policed communities, needs to change. And you hear people talking about it all the time and nothing ever changes. There needs to be a lot more support for people in marginalized communities, people from racialized families, people from over-policed families who now grow up with their father in jail and their brother in jail and everybody else in jail because they've already fallen victim to the same cycle. There needs to be support for those people to give them paths towards success rather than just following their family footsteps because they have no other option, you know, made clear to them. You know, you grow up in this community, your family has a history in the criminal justice system, you're going to be targeted by the police because they've known you from young, they know who your dad is, they know who your brother is, and on and on and on it goes, and it's just a constant revolving door. So it has to be, even before getting to the community or to the criminal court stage, it has to be community change.
Thank you. And we'll go to Gail.
Thank you. I agree with much of what's been said, but here's the thing. The question originally was, how can we make the change, or who's responsible for the change? So my answer would be, first of all, everybody has to take a look at their role in this process. One of us had, somebody said, oh, you know, the judges can't really make that much of a change but for the person who stands before them. But they have that opportunity each and every time. If, when dealing with the person who is standing before them, they are sensitive to the appropriate issues, they are provided with the appropriate information. And again, then it's incumbent on the lawyers to provide the appropriate information so that the judges can make informed decisions. They can make recommendations in terms of, unfortunately, if probation is still in place, they can make recommendations for probation terms that are actually going to benefit the individual rather than funnel them back into the system. So first of all, we as defense counsel need to be able to provide the judges with accurate and appropriate and fulsome information. Secondly, then, that information should be comprised of programming. It should be comprised of resources. It should be comprised, and I'm saying this, and I recognize that much of our work then becomes pro bono work, because by the time we amass this information and put it together in a nice, neat package such that the jurist is even going to want to look at it. We far exceeded that which legal aid is prepared to pay us. But education is key. So if we're educating the judges about whom they're dealing with, if we're educating even the police who are unfortunately and purposefully over-policing certain neighborhoods, the police themselves need to be educated about persons in those neighborhoods and what it is to live in those neighborhoods, what it is to try and function and actually survive in those neighborhoods. Too often you have police who have no clue. You know, it hurts my heart. I had a client say to me very recently that, you know, why is it that the judges aren't forced to take courses? I'm here in jail and I'm being forced to take courses to prove that I'm eligible to get out on parole. And yet, and judges aren't forced to take any courses to know about all of us who are in jail who they've been sentencing. And I quite agree. I didn't have an appropriate response for him because nobody has said, well, you know, when they go to judges school, same way we go to CPD courses and that sort of thing, I don't believe that in judge school, if you will, these topics, these hard topics are covered off. And if they are, they're not covered off necessarily by people who are on the front line dealing with this sort of thing. Education is key, and it needs to start at every level.
Thank you. And just before I go on to Ryan, well, someone, Carrie, pointed out that the lawyers need to be accountable for giving poor representation. That was something from Carrie. And I'll move on to Ryan.
I totally agree with the point about probation. I've never had a client report that it was useful. And I've had oppressive probation conditions. I remember being astounded, my 18-year-old client being sentenced to a probation for 2 years with a curfew from 6 p.m. to 6 a.m. Which, if you can imagine, you're 18 years old being subject to that curfew. My first thought about it was that he's got no chance. And so that's an example of the system trapping you in. So I completely agree with the point about probation. The one change that if I could make one change to the criminal justice system, in addition to probation, I would like laws that allow criminal records to expire. So automatic pardons, if I can put it that way. So, you know, for most offenses, it's the thought of a lifetime criminal record is such a disincentive to a person to pursue, you know, education, to pursue an entrepreneurial interest, to apply for a job. Because as Gordon pointed out, what's the first question? Do you have a criminal conviction? So one change that I would really like to see, and I think would be in the interest of justice, in the interest of the accused, and in the interest of society as a whole, is for most offenses, after 10 years, an automatic pardon. So that a person who's been found guilty of an offense at the age of 21, he or she can think to themselves, okay, I'm going to have a record for 10 years, but I've got the incentive to stay out of trouble. And when I'm 31, the record's going to be gone. It's going to be sealed. And if I apply for a job, it can't be located by the potential employer. For some offenses, it could be less than 10 years, it could be 5 years. For some offenses, maybe more than 10 years. But the point that the system itself should provide an incentive for people to get rid of their criminal records, I think is in everyone's interest.
Thank you. And I have questions for you guys that one of our viewers is asking. I thought a curfew as part of a probation is an illegal sentence. Can someone give an answer to that?
No, it's not as far as I'm aware. It's an illegal. It's a term. It can be a term of probation. It's not against the law as far as I'm aware.
Okay, thank you. Okay, Ray, are you there?
Yep, I'm right here.
Go ahead.
Yep, I'm here. I just wanted to thank folks for their comments and just say that I agree with a lot of what was being said. I've got a number of kind of comments and questions that I wanted to direct to our panel. I also just noticed that Andrew Vaughn was on our chat. And so I know we didn't have him as a panelist, but I just think it'd be great to, if Andrew's still there, to maybe hear from someone who has worked in the courts for many, many years and might be able to add some perspective to some of the comments that we've been discussing.
I'm just listening. I agree pretty well with everything that's been said. Can anybody hear me?
Yep.
Yes.
Yeah, I agree with everything that's been said. I also agree with Ryan, though, that in some ways we can't ever take out the advantages that wealth bestows on people. And that goes in every aspect of life. But we can make life obviously more equitable. But everything Alison said is just bang on. And Jordana too, in terms of how they keep people stuck within the system. The one thing that drives me the most nuts is something Ryan just said too. The Harper government's changes to the parole to the pardon rules. They made it so much more expensive to apply for a pardon. You have to wait so much longer. I mean, if I don't know why Trudeau hasn't dealt with that. That is something that could definitely help so many racialized people kind of recover from their mistakes so much quicker and integrate themselves back into society. So if you're waiting 10 years after you've done something to get a clean criminal record and before you can apply for a job, it's just debilitating. That's the one thing I would really hope that legislatively that I think is attainable that we can get done relatively soon.
Thank you, Andrew. And I didn't mean to put you on the spot. I just noticed when I was looking through the names that you were on the forum. So I do appreciate your comments. I wanted to actually pick up on something that Gail had mentioned when she was talking about judges and responsibility and accountability, because, I think you're absolutely right that, we hold folks in the system, or the system is supposed to hold folks accountable and lawyers accountable. And it's interesting that you brought up, those who are on the bench. And I don't know if folks remember this case or situation, didn't become a case, a couple of years ago with Justice Christine, I think it's Vic, I don't know if I'm saying her name correctly, but she was at the University of Calgary Faculty of Law, and she was the school's judge in residence, and she was speaking to a group of law students, and she made the comment, and I quote, that she felt uncomfortable walking into a room full of, quote, full of big dark people, end quote, and that she was used to being in a, quote, ivory tower where she's, quote, removed from the riffraff. And that was a comment made from a bencher at the University of Calgary a couple years ago. It was in actually 2018. And so when taken to task, there was little to no judicial oversight for her comments, and just the implications that somebody on the bench could say something like that have heavily influenced a group of law students. And so I think, to your point, Gail, it's incredibly important that if we ask for accountability from counsel, then we should absolutely be asking for accountability and forthright from those who are on the bench, right? Because at the end of the day, we know that judges also occupy a lot of, they have a lot of power and discretion within the context of the court system as well. So I just wanted to bring up that point. And if anybody else wanted to add another comment to judges, then we can go. I'd love to hear from them. If not, I do have another question in regards to strategies and strategic oversight.
Well, just to follow up on that, the backlash against that particular judge who spoke at the University of Calgary was so strong, not only from the students and the faculty at the university, but the legal community in general. The judge actually resigned within a few months. It's a reported decision. She stepped down from the bench.
Yes, she did.
Backlash. Thank God, because I agree. The message that sends to everyone who's part of this community from the inside and out is just horrific. Gail mentioned the client she had who questioned why judges aren't forced to take classes or become more in tune with the type of people that they are judging. And I think it's a fantastic idea. I think that judges should have a better appreciation of the circumstances that lead up to someone coming before them, especially those who end up coming before them on multiple occasions. You know, it's so easy to look at a criminal record and see multiple entries and write people off. And it's something that I speak about at length, that we can't just write people off by virtue of the criminal record they create without actually looking at the circumstances behind those offenses from a personal perspective. And when we take those things into consideration, we recognize the struggle that people have trying to exit the system. You know, I think that Andrew's comment about the difficulty in getting pardons now under the new system, I think that Ryan's suggestion of automatic pardons certainly could take account of that, and we need to do a better job of recognizing criminal records, especially during their youth. You know, I keep coming back to that, but the reality is a lot of the time, you know, I have guys that are got like 25 to 30 entries on their record before they're 21 years old. And at 21 years old, you know, people change. I'm sure we all have, you know, the person that we were at 16, and we're not making the same choices at 25 or 35. And so to not be able to forgive something that someone did at such an early part of their life and set them up for failure later on. And I think that's the part of the criminal justice system that a lot of us really struggle to try to get over, is the fact that it is a setup for people, and particularly people from certain communities.
Thank you, Jordana. Anyone else want to add a comment? I have another question. Alison, go ahead. You'll have to unmute your mic, Alison.
I think the host has to unmute Alison. Yeah.
Oh, Tafik, can you, thanks, Jordana. Tafik, can you unmute Alison, please?
The only thing I couldn't help when thinking about the point that, you know, judges should take more of a stance and help more. I don't want to get too much into a debate about, you know, the intersect of politics and the courts, because there's a good reason that they're kept separate. But I can't help during this conversation thinking about a local judge from Brampton who has been disciplined because of his involvement with a Black advocacy group, and his involvement with that group that simply advocates on behalf of Black Canadians has landed him before the disciplinary tribunal, which may or may not say a lot.
Absolutely.
Ray?
Yes.
Could I just notice that Jacquelyn Dixon also joined in. Jacquelyn, are you to just give her a moment? I'd just like to hear her view also.
Absolutely.
Thank you. Jacquelyn, are you there? I don't mean to call you out.
Hi, good evening. Good evening, everybody. I think I'm not muted anymore. Okay. First of all, I just want to congratulate everybody, the organizers, the host, and the facilitator for this evening. I think this is so well put together. It's organized very, very well. The conversation is very deep and meaningful. And although I wasn't here right from the get-go, I jumped in at a part that was extremely stimulating to my psyche, which is the whole conversation about pardons and the various different approaches towards squashing them or in some cases, in most cases, I would probably think, erasing them entirely. I don't know the statistics on it, but that's definitely something that I would be prepared to champion, because we're talking about things as simple as a DUI. When I say simple, don't get me wrong, because drunk driving kills, okay? But, I'm talking about non-violent offenses, whether it is a simple shoplifting matter or something on those lines that didn't require or didn't involve one person bringing harm to another person in any sort of violent way. So those type of crimes can carry and stay with people forever and a day, and there should be some sort of legislation in place, or some sort of process that is more simplified, that would allow an individual to be able to make atonement and be rid of this and move on by all means. And you're absolutely correct. I think it was Andrew Vaughn that brought it up, that's the one area that I'm a bit surprised that our Prime Minister has not addressed. That is something that he could have easily taken care of. It would go a long way in sending a very positive message to a very underserved community of people. But by all means, keep up. GBKM FM is going to follow this group and your efforts as you continue to pursue your interests. Thank you so much for inviting me, Richard.
Thank you, Jacquelyn, and thank you for your support as always. Ray, you can continue.
Thank you so much. Appreciate those comments, Jacquelyn and Andrew, and our panelists as well. There is someone who wants to make a comment. Richard, you wanted to make a comment. Richard, I do apologize if I misspelled. Ganwi wants to make a comment about judges, pardons, and criminal records. Shafiq, if we can unmute his mic, that would be great.
Ray, who was this?
Richard, last name MWANGI. We'll monitor. Thank you. There you go. Okay, Richard, you're on.
Hey, how's it going? Nice
Good.
to see everyone. Very familiar with a lot of faces here from the trenches of the criminal court. I also do criminal defense. Last I was in court, I think right before the COVID. Ryan, you just won a big case. Congrats. But moving forward, someone mentioned something about judges, lawyers, and accountability. I have to say that is a huge issue in the criminal justice system that I have found. I think, Gordon, you mentioned earlier, you'd be in court doing something and you'd hear a lawyer telling someone, do you want to get out of here really fast? That is both when a person's in custody, when they're out of custody, and they don't know the repercussions or the consequences of a criminal record down the road. And what you'll find is that it will affect everything at the end of, down the road it will affect everything. But there are some judges, very few and far between, that are cognizant to the type of lawyers that just plead people guilty in order to get them out of the courtroom or out of the courthouse or out of jail. They sometimes will give, they'll look at the situation and sometimes maybe give recognizance or bails to people to get out on their own recognizance, because obviously they just wanted to plead guilty to get out of custody. But again, that's very few and far between. On the same note, there are some judges, few and far between, that will look at a situation and say, no, I'm not taking in that plea. I can't, sorry. It's you didn't do it. You have a defense. I'm not taking in that plea. Please find another judge that will do it. But again, that type of accountability, few and far between. Past that, the lawyers that are present here, I've seen in court and have done great work. Andrew, seeing you up there too. And keep on doing the good work, guys. And nice to see you again.
Thank you so much, Richard. Appreciate your comments. I'm wondering now, I wanted to get just some folks' comments on specifically on anti-Black racism and you know the narratives that are circulating, that continue to circulate in mainstream rhetoric around you know, whiteness and the implication of white supremacy. And I just want to you know, precede those comments by saying, again, right, these are difficult and challenging conversations, but because I think we could probably all of us agree that there is profit in the criminal justice system when folks who are the most marginalized and racialized enter into the system. What we haven't yet talked about is the specificities around anti-Black racism in particular, right? And so I really want to bring up this topic because we know that mass incarceration procedures are warehousing, as many of you have mentioned, you have young Black males in particular as clients, but I also think there is a discussion to be had here specifically that talks about or speaks to the ramifications of anti-Black racism and the way in which it is negated or disavowed in our Canadian society, and particularly the way in which it connects directly to the Canadian criminal justice system. So I'll open up those comments to the floor to anyone who would like to begin.
I'm tempted to begin, but okay. I don't know if there'll be time for anybody else, so you have to stop me in between on this point. The first thing that I'd like to point out is, as long as we continue to use the word racialized, we're not saying what we're saying. There's two groups of people who are over-incarcerated in the criminal justice system: Black people and Indigenous people. Mm-hmm. And I have been to Parliament to say, look, stop saying racialized when you say people, you should consider racialized minorities when you're considering bail, because the people who have the problem are the Black people and the Indigenous people. And the Indigenous people have Gladu, we have nothing. If you mix us all with racialized, guess what? They'll say, well, we released all the Chinese people, we released all the brown people, we released everybody else. And we're counted in those numbers, and the problem is not addressed. You're very right. We have a problem with having these discussions, and we should get used to saying what is what. That's the starting point. We shouldn't be afraid of the racial discussion to start with. A brave lawyer many years ago brought the Brown case before the judge, and the judge told him he should be ashamed of what he was doing, and asked him to apologize to the police for what he was doing. It went all the way to the Court of Appeal, and it's at that stage they found, well, that was wrong in the first place. And yes, we have to address racism in the court system, but it is not easy to bring it up in court, and you have to know how to bring it up. But first of all, you have to understand the person before you. And that's what my pet peeve is that you can't do a one hat fits all. You have to know your client, and you have to humanize your client before the court and show the court that we're not dealing with just a criminal. We're dealing with a human being who's gone through many things. And unfortunately, we don't understand the clients. How many of us have been shocked when the client tells us, well, I don't expect to live past 25, so I don't care anymore. But it goes back to something that Valerie said. Valerie said early on, she was talking about being in the court system and watching a case before court and seeing quite obviously that the officer must have been lying, and the judge says, well, I find him credible. What does that do to our youth? They have no trust in the justice system. So they believe what they're standing before is just a game. They do not believe that this is part of their lives. I had one case, and I'll try it, I think after 15 years, I'm not going to cry. But the officers who were 6'5" beat up this little Indigenous woman who was trying to get her check. And we went through the trial, and at the end of it, the judge looked at her and me and her and said, well, if she had all these injuries, why don't we have any pictures before the court? This woman was homeless. And I said, Your Honor, because she was in the custody of the Queen, and the Queen didn't take pictures. And on that basis, he convicted her, saying she wasn't credible. We went outside, and I was apologizing to her for what just happened. She looked at me and thanked me for saying in the 12 years she'd been in the court system, nobody had ever run a trial for her. And then she said, don't worry about it. That's what they do to us. I went to the bathroom and I wept. As you can see, my voice is shaking. So we have a system where we're saying the judges have to change, but we don't know the mindset of the judges to start off in the first place. I don't know who's chosen a bench or how it gets to that point, but it seems that there's a reason to appease the police or the crowns or anybody else at the risk of a client who you might never see again, who the judge may never see again. Okay. So I think I'll stop there because the anti-Black racism issue is one that we have to talk about. And always calling it unconscious, I don't know if it's right. If it's unconscious, it's unconscious. But sometimes it's not.
Thank you, Gordon. Anyone else would like to comment?
So I think that it's on an individual basis with some judges, for sure. There's no question that we've been in front of some judges, and it's painfully obvious from the way they are reaching some of their conclusions that they hold their own racist sentiments. What do we do to fix that? You know, there's a new generation of judges who are coming up, and I would like to think that this next generation of judges don't hold those same sentiments. So that's on an individual level. But when we look at things, and you know, specifically when I think about the sentencing regime that's currently in place, you know, people always say, "Oh, the system's not racist; it's the same law for everyone." But when we look at the way it's applied, it's painfully obvious how racist it is when you compare, for example, the sentence for someone who's charged, for example, with child pornography with someone who's charged for trafficking crack cocaine. And you look at the majority of people who are committing those different offenses by race, it is obvious that the way that the sentencing regimes are being meted out are most certainly racist. And we also see racial disparities in both policing and conviction rates and sentencings in different jurisdictions. I know a lot of us, when we did our introduction, spoke about the various jurisdictions that we traveled to. And, you know, I think the further away we go from Toronto, and that's not to say that Toronto doesn't have its own issues, but the further away you go from Toronto, the more likely it is that the system is designed to work at a detriment to Black accused. And, you know, sometimes I say it as a joke to some of my clients that are arrested in illegal stops. For example, I had a client who was pulled over basically for being Black while driving a Mercedes in Midland, which I believe in itself is probably a crime. And he was so frustrated by what had transpired because it was essentially an HTA stop that exploded into a full-blown search of his car, including the trunk. And during the course of his arrest, the officer actually made a comment about how this particular person did not belong in Midland, as though Midland itself has its own classifications for people. And to try to lighten it up, I said to him, you know, there's two types of people who shouldn't be in Midland, you for being Black, me for being Jewish. We just don't belong. And he sort of laughed about it, and we said it, you know, to sort of get over this very difficult position he was faced with upon his arrest. But the reality is, you know, we have to start challenging these illegal arrests more often, and there's some decent appellate case law that are supporting our positions against these racist stops that are so often coming across our desks. And so I think that part of the challenge has to start with the defense bar in, you know, challenging these. And he ends up in jail in Penetang, and they're like, "Oh, well, you're just going to plead guilty, right? It's a gun, fentanyl, and it's in your car." And he knows that I'll challenge the basis of the stop, and luckily, you know, we'll do that for him. But the tenor up there, and in a lot of these smaller towns, is, well, you know, you're caught, so you're just going to plead guilty. And in doing so, you're allowing the police to continue on in this behavior. And so I think that, you know, those of us who are on the defense side need to start really pushing the envelope on these types of cases in order to highlight what is exactly as Gordon has labeled it. It's anti-Black sentiments.
Thank you, Jordana. Yep, Alison, you wanted to add? Sorry, you're mute. Tafiq, can you unmute Alison's mic, please?
There we go.
Thank you.
I was just I don't have anything particularly insightful to add, but a large part of my practice these days is in Barrie and Midland, challenging driving while Black stops. And thankfully, I've developed a practice such that many clients are calling me specifically now because they know I will challenge it. And so it's become a large part of what I do these days. And I have had not an insignificant number of Crown attorneys, police officers, local lawyers, defense lawyers, say to me, well, the only reason that Black people are up here is to deal drugs. I have lost count of how many times I have heard that not only from police officers, but from Crown attorneys and, in fact, local defense lawyers. So it is a big, big problem. I have most experience, particularly with that area, but I suspect it's broad throughout smaller communities in Ontario.
Absolutely. Thank you, Alison. Ryan, did I? Yeah.
Yeah, if I can tell you the area that I'm most concerned about in jury trials, because Gordon's right. When you're talking about a racialized accused in the context of the criminal justice system, the two groups that really start with a stigma in the criminal courtroom and start at a disadvantage, I think he's right, are Blacks and Aboriginals. So those are the two groups that if I have a Black or Aboriginal client, I'll do a challenge for cause in the jury selection process for that reason. But Parliament has eliminated peremptory challenges. So the one way that the defense could have some control and the accused could have some control over the makeup of the jury has been taken away from defense lawyers by Parliament. Why? Because related to the Gerald Stanley trial in Saskatchewan and the perception that it was unjust or wrong that Gerald Stanley was using his peremptory challenges to get whites on the jury in that case. But the effect of the law is to make it so a Black accused has no control whatsoever over the composition of their jury. So I can tell you, I had an experience recently with Gail. Both she and I were running importing trials in Brampton recently. This was in January. I had a Jamaican accused. Will never forget it, the look she gave me. She looks at the panel comes in, and a jury trial, everybody comes in. So you can see, how many Blacks are in the room before jury selection begins. And my client turns to me with fear in her eyes, and she says, "Ryan, can you please try to get as many Blacks as you can on the jury?" I'm looking at her and she, haunted by the fear she had that she was going to end up with, an all-white jury or no Blacks on the jury in particular. And I said to her, "Of course I can." So luckily in Brampton, there were at least some Black jurors, and we ended up with 2 Blacks on the jury, one of whom was the foreman who came back and acquitted her, or at least read the acquittal of the jury verdict. But the point I'm making is because of the wisdom of Parliament, defense lawyers no longer have any control over who gets on the jury. It's completely out of our hands. Therefore, it's completely out of the hands of the accused. And I'm worried because anti-Black racism is a factor in a criminal courtroom among the citizens. I've seen many who won't look at my clients who are Black or give them dirty looks in the jury selection process. And we no longer, as defense lawyers, have the ability to challenge them. So, and not only that, you still get to ask the challenge for cause. Now the judge makes the decision. Every time I've done the challenge for cause, there are people who do admit that yes, in fact, I can't judge this case fairly and without bias because the accused is Black. So I can say that in terms of my experience with anti-Black racism, I'm most concerned in the context of a jury trial. And I've not done a trial yet without peremptory challenges, but very, very worried about the prospect that you have a Black accused who has no control whatsoever of the composition of the jury, and you don't even get the opportunity to select Black jurors. I think many will feel that is not a jury of their peers if they don't have that opportunity to get any Blacks on the jury at all. So that's my one thing I'm very concerned about with respect to anti-Black racism and the change, eliminating peremptory challenges.
And just to add on that, that is a huge problem. And even behind that problem is the fact that as it stands, jury pools are not representative of their communities. And I went, it's probably 3 or 4 years ago now, I had a trial for an African-American client in Guelph, and it was a jury trial. He wanted a jury trial. We walked in that morning, and I mean, Guelph is pretty white, but it's not all white. And we walked in that morning, and there was 200 white people looking back at him, not a single minority to be seen, literally in the entire room. And he broke out into a cold sweat and told me right then and there to re-elect Judge alone because he didn't stand a chance. So he's entitled theoretically to a jury trial, but not of one by his peers.
Thank you so much, Alison and Ryan and Jordana and Gordon and Gail for all your comments. I want to be mindful of the time because it's about 10 to 9 here, and I wanted for us to close with some strategic comments, if you will. You know, Gordon had mentioned the Gladue case, and I was thinking about that because even in hindsight, Gladue hasn't done what it was intended to do at the onset, right? And so we know that there have been a number of reports, there have been a number of commissions, there have been a number of, suggestions, implementations within the police force, all of these discussions that tend to take place in regards to racial disparities. And so to close, one of the things I'm interested in, if the panel can speak to this, is racial disparities, they absolutely foster public mistrust. And so the ramifications of public mistrust is that there is a lack of education, as Gail mentioned earlier, on all fronts. So for folks who are enmeshed in the system as well as those who are part of the system. But I'm wondering if people can maybe comment in terms of, strategically what they think might be or what they can offer in terms of strategically our next steps around in regard to discussing race and exclusion in the system. And I'm really asking this question to hopefully bring to the forefront that we know that specific communities are targeted. We know that there's a lack of information, a lack of education in regards to, ventures and even folks who are on both sides of, defense and crown. So I really am interested in here in terms of what people think we can strategically do in terms of, making adjustments to, or beginning to at least make adjustments to the system in regard to the topic that we have tabled tonight. So anybody is free to start.
Okay, well, I'll start. As I was saying before, I think defense counsel play the largest role. We're the ones who get to speak on behalf of our client. We're the ones who are addressing the jurists who are making the major decisions, whether it's on guilt or whether it's on sentencing. And so it's important that we first make it our business to have an understanding of who our client is and recognize that they may not even realize the racism that has been a part of their experience through the judicial system. I mean, without rehashing how it plays out from being over-policed, even those in custody, inmates in custody. First of all, there's an over-representation there, but not only that, their experience while in custody, whether they're being labeled as a gang member when they shouldn't be, or whatever. So it's our job to try and inform those that are part of the system. And in doing so, then, something that I know that I've been working on with some others is a pre-sentence reports. We all know that the average pre-sentence report is written by somebody who's likely adverse to our client. It's a probation officer. It's somebody who will ultimately be able to, quote, get our client in trouble, have them arrested if for whatever reason they've missed a meeting or haven't abided by a condition. If we are getting reports about our clients that actually speak to who our client is, speak to our client's history, speak to our client's experience, speak to our client's experience with respect to education, with respect to their home life, then at least the judges are given a better opportunity to see the person standing before them and not just the color of the person that's standing before them. So one of the things that we can be doing is accessing pre-sentence reports that are broader and are more in depth and are more specific and are culturally sensitive. And the other thing is having more of these conversations so that other counsel are brave enough to put these issues before the court. I mean, it's one thing for us to say, well, we all know racism exists, and we all know that there are particular participants that are working from a perspective of racial bias or what have you, but we got to name it. Not only do we have to name it, but we have to challenge it. So, you know, unfortunately, a lot of it falls on the shoulders of defense counsel, but I think, as I said, good reports and even helping one another. If there's somebody out there that doesn't know how to name it, doesn't know how to apply, you know, reach out to somebody who does and get help so that we can call it and name it and hopefully eradicate it.
Thank you so much, Gail. Well said. Anyone else from our panel?
I certainly agree with Gail on the need for more culturally sensitive pre-sentence reports. I think, and I agree that this fight within the justice system falls on the defense. I certainly don't believe that the Crown attorneys are about to fight for racial equality for our clients. They won't fight for anything for our clients, quite frankly. But I think the fight starts earlier. I think that it has to start with taking the police to task for racist policing, for bias policing. I think that we have to do a better job of calling it what it is. Some of us do, not all of us. I think more of us. And I think that we have to start, encouraging our colleagues to do a better job of calling out those police officers in those jurisdictions, like Midland. Hamilton's no better. I have a huge practice there. Racist policing is through the roof. I think I probably once a month get a illegal HTA stop that ends up with the police officers more often than not conducting what can be construed as a strip search at the side of the road. Like, it's really bad out there. So I think that we have to do a better job of taking the police to task and showing the courts, what the appellate courts have to say about this, because the small town judges aren't paying attention to the charter decisions that are coming out. And so those of us who are based in, Toronto or Brampton that are very much familiar, or even further away that are at least in tune to these issues, are aware of what the Supreme Courts are saying, what the appellate courts are saying. And the small towns, if no one's pushing these issues into the face of the judges who are making the decisions at the risk of being appealed, then we're failing our clients. So I think that we have to do a better job of trying to educate the judges through litigation that we put in their courts.
Absolutely. Thank you, Jordana. Well said. Any other comments? Ryan, Alison, or Gordon?
Maybe I'll just say briefly, I also agree with Gail and Jordana. It starts earlier. It's always been interesting to me. To me, I see a problem where the people who are decision makers, politicians, for example, are very often the worst people to make decisions about what to do with respect to crime or with respect to policing. And it's not because they have bad intentions; they just don't know. And John Tory, he seems like a great man, but he went to UCC. He has no exposure whatsoever to a community that's, for example, over-policed. Or where there's certain criminal activity, or where there's a high school with dangerous elements. There's just no knowledge on the part of decision makers. So I've always been interested in, instead of someone like me saying, okay, well, what do you think is the strategy? Well, I also don't know. I don't have any magical insight. But the people who do know, we never hear from. They're never spoken to. Ever. So I've always been interested in what are the ideas and strategies that come from someone who is in that situation. And very often I get the best insights from my clients. So I just think there's a problem that I see with the conversation that, we have a gun problem. So Doug Ford is going to throw $50 million at the special bail team for gun bails for the Crown Attorney. And okay, fine. Your intention may be great, but what is the effect of the policy? What is the effect that that is going to have on the crime rate? Is it going to go down? And usually the answer is no, not at all. If anything, it has negative effects. So if I can say anything strategically, it would be to involve people in the process who know the answers to these questions, not a top-down approach from people who, despite their good intentions, really don't know the answer to the question as to what is the best strategy to reduce gun violence.
Right. And I thank you for your comments, Ryan, as well. And I'll just interject here. I know we don't have time because this is a whole nother Zoom panel, but you mentioned John Tory, and I will say to your comment in regards to the fact that he doesn't know, and I will respectfully disagree with you on that comment, only to say that folks that have privilege in our society have the unearned privilege to not have to know. Right. And that's something that's how privilege works. And that's what power looks like. So I don't think we can give John Tory and others folks like him a pass and saying, he's well-intentioned and he just doesn't know. That's a choice that he makes. And that's how folks' whiteness protects them. That's essentially how things stay intact. So I just wanted to interject that comment, not to take away from your other comments, but just I think it's really important that we cognizant remember when we are having discussions about race and racism, right? The folks who created these structures of systemic and institutionalized racism and bias, right? They're starting from a point of where they're trying to protect their own privilege and power. And it's absolutely essential that when we have conversations about anti-Indigenous and anti-Black racism, that we understand that that's how power is entrenched, right? So the ability to not have the conversation is what privilege looks like. Right? It's not because Tory and the rest of them are not well-intentioned, but that's an unearned privilege that they have in society that works for them. So I just wanted to make that point. And I just wanted to, we haven't heard from Alison and Gordon. I want to give our finalists kind of, an opportunity to speak. And I know Jacquelyn Dixon also wanted to comment after our panelists, and I'm also mindful of the time. It's 9 o'clock. So if Alison and Gordon have any, quick comments to add, we can go there. If not, we can proceed to Jacquelyn.
The only thing I will say very quickly is I agree. I think it falls enormously on the shoulders of defense lawyers to challenge the police. And it's not until there is a pattern of police misconduct being called out rather than 1 out of every 15 or 20 cases being called out in court that anything is going to actually change.
Absolutely. Thank you, Alison. Gordon, any final thoughts? We'll get Tafik to unmute your mic. Just 1 second.
It was me. I muted it. Many thoughts that we could not deal with today. Ray, I have to add to what you were saying in terms of Ryan's comment, because in 1995, the Systemic Racism Report came out with its recommendations. In 2008, the Roots of Violence, Youth Violence came out as well, with very, very, very similar recommendations. The system has created a petri dish for violence in certain areas, violence, gang warfare, and so on. And the governments keep on going back to pumping more into the justice system as opposed to, we all know it. If you're building more jails and you're building less schools, you're just going to fill the jails and you're not going to fill the job places for people.
Absolutely.
So that's on that front. And what can be done in the court system, I think we have to develop a discourse that people actually understand what we are saying. And Ryan's, what happened to Ryan tonight is a perfect example. He is speaking and somebody bombs over him, and we don't hear it. We have to develop a discourse where we are heard. And it's not just noise. We are being listened to. So I have other things in my head on that about developing a discourse, but I'll leave that for now for Jacquelyn to make her final thoughts.
Thank you so much, Gordon. Okay, Jacquelyn, we'll go to you right now. And Tafik, if you can unmute Jacquelyn Dixon's mic, please.
Hi, good evening. Thank you so much once again. Thank you for even making time for my final thoughts. There's something that's been pressing on my mind since joining the conversation tonight. And it started when we were talking about sentencing and the having the conversation about race and the unjust justice system. And the thing that comes to my mind from interviewing so many people, having this conversation and being witness to the lives of so many young people being shattered as a result of simple mistakes, is how it's the demeanor of the convicted individual once they have experienced that first crime, that first offense. So the first offense, if we're going to address why our people, our community, has such an egregious amount of repeat offenders, we have to ask what happened at the first offense, at the first criminal conviction. And here's my takeaway. At the first criminal conviction, or prior to the conviction, the young Black person is often told before the conviction even takes place, as soon as they are charged, you're finished, you're done. That's it for you. The police are going to follow you for the rest of your life. You're never going to get a job. That's it for you. These type of things play on a young person's mind. And these are the type of conversations and informations that that young person needs to, reassurances that they need to get from their defense attorneys that don't worry about it. This is nothing to worry about. I'm going to help you to get a pardon if even a conviction takes place. This isn't as tragic as you think it is. And the reason why I'm saying that is because that's what the Caucasian child is hearing. They're being reassured that this is not detrimental. This is not going to determine how your life is going to end. Whereas with the colored child, they're being told right from the onset that you're done. Now, when you look at it from that perspective, what deterrent is there to you to not commit a second offense? What deterrent is there? If we're not encouraging these people that, listen, there is such a thing as a pardon. If a conviction should take place, we're going to aggressively pursue this. We're going to make sure that this is wiped off your record. You have a vibrant, long, successful life ahead of you, rather than the counter, which is what, in my opinion, most Caucasian young children are told. They feel very much confident and optimistic about their future after a first offense, whereas a Black child does not.
Right. Thank you so much, Jacquelyn. Folks, it is 9:05. I want to be mindful and cognizant of the time. I also, before I thank our panelists, want to just remind folks to please go to the Keep Six website. There is a survey there, and we're very interested in having your comments. You know, one of the things that we've talked about is collective community collaboration, and providing constructive, critical comments is one way in which we can continue to keep this conversation going. So I just want to take the time to thank folks for joining us on the forum tonight. Would like to thank co-hosts Rachel and Richard and all of our panelists. Thank you, Alison, Gordon, Ryan, Jordana, Gail, as well as Jacquelyn and Richard M. and Andrew Vaughn for their comments, and just really want to underscore that my appreciation for folks' forthrightness in terms of having very challenging conversations and all of the work that we all need to continually do. So I will leave my comments there and turn it over to Richard to have the last word.
Thank you very much. I just want to say thanks to everyone also. Alison, Jordana, Gordon, Ryan, Gail, and also Ray. I really appreciate your support. Jacquelyn, I appreciate your support all along, and thanks for coming out. I just noticed even a young man. I'd love to have you in the next panel-ish. I just saw you here just a while ago. I haven't seen you in a long time. Thank you for coming out. And I just like to say that this is something that I'd like to continue within the community. where we can all get together and find means of addressing issues that arises in the community, and we can work towards changes. And I think this is very, very important. And I'm very privileged to have the support that I have in the community from a legal aspect and from everyone here tonight who have known some for many, many years, and others we've just met. And I'm hoping to continue your support in my work in the community and what I'm trying to make changes and so forth. And I just want to say thank you and blessings.
Thank you. And also, Richard, my bad, I totally forgot to shout out Valerie Steele.
Yes.
A stalwart in our community. No disrespect, just my bad. Lots of folks to thank. So thank you, Valerie, and all of our panelists. And folks, have a wonderful evening and all the best for the rest of the week.
Thank you. Thanks for organizing.
Thank you.
Yeah.
Thanks a lot.
Thank you.
Yeah.